Mr. Paul, thank you for joining us. I was fortunate enough to discuss this issue before the House Financial Services Committee just last month and to express my concerns regarding the perpetual debt trap that these products leave and create for some of our most vulnerable residents and consumers. I want to ask you about CFPB's stated justifications for the proposed rule. They seem to share a similar focus. The proposed rule states, and I quote, "A more robust and reliable evidentiary record is needed to support a rule that would have such dramatic impacts on the viability of payday lenders." Mr. Paul, other than the industry just not liking it, by what measure are the 5 years of research and outreach leading up to this rule not robust or reliable evidentiary record?
Thank you. I think the best example is reflected in the exchange that I just had with the members. Essentially, on one key determination as a matter of law that needs to be established, there was one study in the record. There's great debate, controversy as to the strength of that, as well as how limited in scope that study is. And it is looking, not at overall the quantum of evidence that came in, but the evidence on some specific issues on which we need a factual predicate that was, our preliminary conclusions that was weak. So we went out and asked the public, is this all there is, or is there other evidence on this specific point? It's not that we didn't get a lot of comments. We get 1.4 million comments last time. It's not that there aren't a number of studies that we considered as part of our analysis, but on the particular point that we have to establish as a matter of law to justify the provisions in the rule, the research on that particular point we thought was weak enough that it justified going out and seeking public comment on that particular issue.
All right, well, in the interest of time. So CFPB also says that the 2017 rule is welfare decreasing for lenders and, quote, "reversing the restriction should therefore be welfare enhancing for lenders," unquote. Mr. Paul, what is the name of your agency?
The Consumer Financial Protection Bureau, or the Bureau of Consumer Financial Protection.
Consumer, right? So why should the Consumer Financial Protection Bureau care about enhancing the welfare of predatory lenders? Are these lenders new consumers?
Lenders are not consumers. I think, though, that the language that you're quoting from or paraphrasing is incomplete. Immediately following those statements in the notice of proposed rulemaking, there is an indication by the agency that those estimates are based upon assuming that consumers don't adequately understand what their risks are for taking out payday loans and being able to avoid them. So essentially what happens is that that conclusion as to the welfare effects also is contingent upon the state of the record with regard to whether consumers anticipate loans or not. Anticipate their experience.
Okay. So, but then let me just go on then. So then following the concern for lenders' welfare, then the CFPB states that the primary impact of the proposed rule would be, and I quote, "a substantial increase in the volume of loans and a corresponding increase in the revenue lenders realize from these loans," unquote. Now, many would argue that the primary impact is to hurt consumers, but I guess you're right that the flip side of that is to line lenders' pockets. So yes or no, is that an important consideration for the CFPB?
When we do rulemakings, we look at the costs and the benefits of the rules that we put into place. The effects on industry, the effects on consumers are both things that we consider as part of our 1022 analysis, which is required by the Dodd-Frank Act.
I have to reclaim my time just in the interest of time here. So the proposed rule does not leave this to speculation, however, Mr. Paul. CFPB's own cost-benefit analysis includes a projection of the additional amount that the predatory lenders will be able to extract from borrowers if the 2017 rule is repealed. So that additional revenue is around $8 billion per year. Is that correct?
That is correct, yes.
Okay. So while borrowers are struggling to make ends meet, the agency tasked with their protection is busy gifting predatory lenders $8 billion a year. Is that correct?
I wouldn't describe it as gifting, and we are.
I'm sorry, in the interest of time. This confusion around the CFPB's mission even extends to court filings. When the payday lenders sued CFPB to block the rule, your agency joined hands with the industry suing it and asked the court to stop CFPB's rule from taking effect. In that joint motion, CFPB stated that, quote, "the balance of equities heavily favors a stay, particularly in light of the irreparable injury that the payday lenders face," unquote, and I yield.